Hello and welcome to Verdictum. I'm Sheetal June, and in today's episode we will talk about Article 25 of the Constitution, essential religious practices and related cases. Last week, the Supreme Court, in an interim order, partly stayed a Mumbai college's circular banning hijab, cap and badges on the campus while refusing to stay the ban under the same circular on a burqa, niqab and stole. A division bench of Justice Sanjeev Khanna and Justice Sanjay Kumar asked that the interim order be not misused, as it reminded that the issue at the centre remains pending before the top court. A two-judge bench of the Apex Court on October 13, 2022 had delivered opposing verdicts in the hijab controversy emanating from Karnataka. The state government had imposed a ban on wearing the Islamic head covering in schools there. While Justice Hemant Gupta, since retired, had dismissed the appeals challenging the judgment of the Karnataka High Court, which had refused to lift the ban, Justice Sudhanshu Dhulia had held that there shall be no restrictions on wearing of hijab anywhere in schools and colleges of the state. The court thus is due to finally decide as to whether hijab should be allowed in variation with the standard uniform prescribed under Article 25(1) of the Constitution, which guarantees the freedom of conscience, the freedom to profess, practice and propagate religion to all the citizens. The right, however, is subjected to reasonable restrictions and can be limited by arguments based on public order, morality, health and other rights-related provisions in Part 3 of the Constitution. It is under this article only that Sikhs are allowed to carry kirpan, as it forms a part of the profession of their religion. In Bijoy Emmanuel versus State of Kerala 1986, students belonging to the Jehovah's Witnesses denomination were allowed to refrain from performing the national anthem, which they argued contradicted their religious beliefs. In the popular case of Anand Magi, the Supreme Court had held that the Tandav dance with human skulls and lethal weapons in public places was not an essential religious riot, and hence the order by the police to stop such a function was not violative of Article 25(1) of the Constitution. In the landmark ruling of Shaira Banu versus the Union of India, the top court in 2017 struck down the triple talaq practice, declaring it unconstitutional for violating principles of gender justice and equality enshrined in the Indian Constitution. The court declared that the practice was arbitrary and not an essential part of Islamic law. The court said that because triple talaq is illegal in most Islamic nations, it cannot be considered an essential practice. The court also stated that personal laws must be tested for constitutional legality and gender fairness, and Article 25(2) states that any religious practice that breaches fundamental rights may be overturned by the Supreme Court. It determined that the practice of triple talaq was disparaging and violated Article 14. Now coming back to the present matter, the Bombay High Court had trashed the petition against the ban and said the dress code was applicable to all students irrespective of their religion or caste. The students who were in the second and third years of the science degree course had moved to the High Court, challenging the directive, arguing that the college's action was arbitrary, unreasonable, bad in law and perverse. The High Court, however, had said it could not see how the prescription of the dress code by the college violated Articles 19(1)(a), freedom of speech and expression, and 25, freedom to practice religion of the Constitution. The court had also refused to accept the petitioner's contention that wearing a hijab, niqab and burqa was an essential practice of their religion. Prescribing a dress code should be seen as an exercise towards maintaining discipline, and the right to do so flows from the fundamental right to establish and administer an educational institution under Article 19(1)(g), right to practice any profession or to run trade business. And Article 26 of the Constitution, the High Court had said. The dress code was mandatory only within the college premises, and the petitioner's freedom of choice and expression was not otherwise affected, the court stated. With a slew of different opinions on the subject matter, the Supreme Court's final decision remains much awaited. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.